Good day, ma'am. I am Cindy Abjelina from BSHM 3A, and I'm here to report to you about the laws related to tourism, investments, and finance. But before we proceed, let us hear first the learning objectives. Enumerate the procedure in setting up a tourism-oriented business. Explain the laws governing tourism investments and financing tourism-oriented projects. Discuss the business models applicable to tourism projects. Enumerate the various taxes application to tourism-related establishments, and discuss the limitations of foreigners in tourism investments. So this chapter deals with laws related to promotion, monitoring, and regulation of tourism investments and finance in the country. Basically, this will tackle the participation of foreign investors as well as incentives given to Filipinos in case they will invest in the tourism industry. Special laws are even created to address needs of certain sectors like the informal sector, Filipino balikbayans, retirees, and senior citizens. So on the next slide, we have here the Foreign Investment Act of 1991. So the term Philippine national shall mean a citizen of the Philippines or a domestic partnership or a association wholly owned by the citizens of the Philippines. It is either a corporation that is organized under the laws of the Philippines, of which at least 60% of the capital stock outstanding and entitled to vote is owned and held by the citizens of the Philippines, or either it is a corporation organized abroad and registered as doing business in the Philippines under the Corporation Code, of which 100% of the capital stock outstanding and entitled to vote is wholly owned by Filipinos, or a trustee of funds for pension or other employee retirement or separation benefits. So whether the trustee is a Philippine national, and at least 60% of the fund will accrue to the benefit of the Philippine nationals, provided that where a corporation and its non-Filipino stockholder own its in a Securities and Exchange Commission registered enterprise, at least 60% of the capital stock outstanding and entitled to vote of each both corporations must be owned and held by citizens of the Philippines in order that the corporation shall be considered a Philippine national. So the phrase doing business shall include soliciting service contracts, opening offices, whether called liaison offices or branches, appointing representatives or distributors domiciled in the Philippines or who in any calendar year stay in country for a period or periods totaling 180 days or more. So, the Republic Act 7042, as amended by the Republic Act 8179 on March 25, 1996, also known as the Foreign Investment Act of 1991, provides that the policy for that foreigners can now invest in all the activities and enterprises in the Philippines except those covered in the negative list. So when a foreigner investment in the Philippines is not covered or does not seek incentives under the Omnibus Investment Code, the foreign national or the entity can ascertain the extent of allowable foreign equity in the enterprise sought to be entered into by simply referring to the negative list and filing the necessary requirements with the Securities and Exchange Commission. Under the Foreign Investment Act of 1991, a foreign national or equity must determine the kind of enterprise sought to be entered into, whether the enterprise is domestic market enterprise or a export enterprise. So on the next slide, we have here the procedure for registration. So a foreign national or entity not seeking to avail on incentives under the Omnibus Investment Code shall file an application of registration form as follows. First, we have here the corporation and partnership. So with the Securities and Exchange Commission or the SEC, the existing requirements for foreign corporations are: first is the name verification slip, the certified copy of board resolution authorizing the establishment of a Philippine office, the financial statements as asserted by an independent certified public accountant of the home country for the immediately preceding year at the time of filing of the application. Fourth, we have the certified copies of the articles of the incorporation or the partnership with English translation. And the fifth one, we have here the foreign company information sheet. And the sixth one is the proof of inward remittances such as bank certificates or inward remittances or credit advices. So second, we have here the single or sole proprietorships. So with the Bureau of Trade Regulation and Consumer Protection or the BTRCP of the Department of Trade Industry, aside from the registration requirements as mandated above, the Section 125 of the Corporation Code requires foreign corporations wishing to do business in the Philippines to secure a license from the SEC, allowing foreign corporations to do business in the Philippines. So next slide, we have here the investment in transportation, business, and public utilities. So in Article 12, the National Economy and Patrimony, Section 11, no franchise, certificate, or any other form of authorization for the operation of a public utility shall granted except to citizens of the Philippines or to corporations or associations organized under the laws of the Philippines, or at least 60% of whose capital is owned by such citizens, nor shall franchise, certificate, or authorization shall be exclusive in character or for a longer period than 50 years. So neither shall any such franchise or right be granted except under the condition shall be subject to amendment, alteration, or repeal by the Congress when the common good so requires. So for common carriers such as the airline, land, and water transportation businesses, the operations of such involve public service shall be granted only to citizens of the Philippines or to corporations or associations organized under the laws of the Philippines. So or at least 60% of whose capital is owned by such citizens. So in other words, foreign participation is limited to only 40%. In addition, the executive and managing officers of the corporation or association operating a transportation business shall be exclusive to citizens of the Philippines. So on the next slide, we have here the investment in travel agencies and tour operators. So the following may apply for accreditation as tour operator. First is a resident Filipino citizen, a partnership organized under the laws of the Philippines, at least 60% of its capital being owned by a Filipino citizen, and the last one, the corporations organized under the laws of the Philippines, at least 60% of the subscribed common or voting shares of stocks of which is owned by Filipino citizen, and the composition of its board of directors being at least 60% Filipinos. So the above provides the limitation of a foreign participation to 40% purposes of accreditation and operation of a travel agency and or tour operator by the Department of Tourism. So in addition, the Memorandum over Order number 211 approving the 2006 Investment Priorities Plan on April 4, 2006, tourism, which covers travel agencies or tour operators, has been classified as preferred activities pursuant to Article 29 of the Omnibus Investment Code of 1987. Thus, in order for a travel agency or tour operator to be entitled for registration under the investment of priorities and plan. So on the next slide, we have here the application of the retail trade law of restaurants and shops. So, restaurants and tourism-related establishments such as department stores and shops are governed by the laws on retail trade by reason of the nature of their business. So, in the past operation, ownership of these establishments are confined only to Filipino citizens or to corporations and associations fully owned by the Filipino citizens. Reason of the enactment of the Retail Liberations Act of 2000, foreign investors may engage in retail trade subject to the requirements referred to the Chapter 10 laws on regulating restaurants and other tourism-related establishments. So, on the next slide, we have here the tourism project under the build, operate and transfer, or the BOT program. So in Republic Act number 6987 as amended by the Republic Act 7718 referred to as the BOT law, implements the declared policy of the state to recognize the indispensable role of the private sector as the main engine for national growth and development and provide the most appropriate favorable incentives to mobilize the private resources for the purposes. So, the coverage of the BOT law extended not merely to government infrastructure projects but also to government development projects. So the following are the schemes are recognized under the law. First is we have here the build and transfer, or the BT. It is a contractual arrangement whereby the project proponent undertakes the financing and construction of a given infrastructure or development facility and after its completion turns it over to the agency or the LGU concerned, which shall pay the project proponent on an agreed schedule its total investment expended in the project plus a reasonable rate of return thereon. Next, we have here the build, lease, and transfer, or the BLT. It is also a contractual arrangement whereby a project proponent is authorized to finance and construct an infrastructure or development facility and upon its completion turns it over to the agency or the LGU concerned on a lease agreement for a fixed period, after which ownership of the facility is automatically transferred to the agency or the LGU concerned. Next, we have here the build, own, and operate, or the BOO. It is also a contractual arrangement whereby a project proponent is authorized to finance, construct, own, and operate and maintain an infrastructure or development facility from which the project proponent is allowed to recover its total investment, operating and maintenance costs, plus a reasonable return thereon by collecting tools, fees, rentals, or other charges from facility users. So next, we have here the build, operate, and transfer, or the BOT. It is a contractual arrangement whereby the project proponent undertakes the construction, including financing of a given infrastructure facility and the operation and maintenance thereof. So next one, we have here the build, transfer, and operate, or the BTO. It is a contractual arrangement whereby the LGU contracts out the construction of an infrastructure facility to a private entity such as the contractor builds the facility on a turnkey basis. So assuming cost overruns, delays, and specified performances risk. Next, we have here the contract add and operate, or the CAO. It is also a contractual arrangement whereby the project proponent adds to an existing infrastructure facility which it is renting from the government and operates the expanded project over an agreed franchise period. Next, we have here the develop, operate, and transfer, or the DOT. A contractual arrangement whereby favorable conditions external to a new infrastructure project which is to be built by a project proponent are integrated into the arrangement by giving that entity the right to develop adjoining property and thus enjoy some of the benefits the investment creates such as higher property or rent values. Next one, we have here the rehabilitate, operate, and transfer. So a contractual arrangement whereby an existing facility is turned over to the project proponent to refurbish. So operate and maintain a franchise period at the expiry of which the legal title of the facility is turned over to the government. So last one, we have here the rehabilitate, own, and operate. So it is a contractual arrangement whereby an existing facility is turned over to the proponent to refurbish and operate with no time limitation imposed on ownership as long as the operator is not in violation of its franchise. It can continue to operate the facility in perpetuity. So next one, we have here the franchising. So franchise is a privilege given to a dealer by a franchise service organization to sell the franchisor's product or services, including the trademarks and trade names. So in a given area with or without exclusivity. So such arrangements are sometimes formalized in franchising agreement, which is a contract between a franchisor and a franchisee, wherein the former may offer consultation and promotional assistance, financing, and other benefits. The franchisee must pay a franchisee fee for such right. In addition, the franchisee is typically required to use the franchisor's product. So, the above mentioned is a franchise is a license from the owner of a trademark or a trade name permitting another to sell a product or service under that name or mark. So more broadly stated, a franchise has evolved into an elaborate agreement under which the franchisee undertakes to conduct a business or sell a product or service in accordance with methods and procedures prescribed by the franchisor. And the franchisor undertakes to assist the franchisee through advertising, promotion, and other advisory services. So, I guess that could be all, ma'am. Again, I am Cindy Abjelina from BSHM 3A. Thank you.